Good afternoon, this is Sean Golding from Golding & Golding, here to discuss a common concern we get from many clients, especially after reading all the fear-mongering garbage you'll find online about criminality and foreign account compliance, or non-compliance rather, and it's whether non-citizen immigrants are at bigger risk or greater risk for criminal prosecution if they have unreported accounts, assets, investments. Right? The answer is no, right? They're not. And the fact that some attorneys like to really go out there and grind it out and make it sound like you're automatically going to get deported or removed because of some foreign account non-compliance is absurd. So let's go through the basics. The term U.S., a non-U.S. citizen, is different than non-U.S. person, okay? So when we're talking about non-citizens, we're primarily talking about visa holders who meet the substantial presence test, H-1B, L-1O, EB-5, B-1, B-2, and lawful permanent residents, legal permanent residents, green card holders. It can also include foreign nationals who otherwise meet the substantial presence test, but for the most part, non-citizen is going to include a lawful permanent resident or a visa holder who meets the substantial presence test and therefore is required to pay U.S. tax on their worldwide income unless they meet like the closer connection exception or a different sort of exception or exclusion. In general, whether you're a U.S. citizen or non-citizen, criminal violations of foreign account non-compliance are rare, okay? Now, merely not reporting a bank account without criminality does not make you a criminal, right? Now, most of the time, if someone's going to get indicted for a criminal violation of foreign accounts non-compliance, it's ancillary to other more serious issues like tax evasion or money laundering, smurfing, structuring, all that kind of stuff. Standalone foreign account non-compliance doesn't tend to bring up or conjure a criminal violation, okay? Civil willfulness is not the same as criminal willfulness. If you get indicted for a crime, whether you're a citizen or a non-citizen, they still have to go through the criminal procedures and they have to show that you were willful beyond a reasonable doubt. And while there's no specific quantifying what beyond a reasonable doubt means, other than it's the highest threshold, it's thought of as 95%, okay? Most of the time, when you have foreign account non-compliance, unreported foreign income, unless it's like mixed in a whole bunch of offshore companies with the intent to evade, it's going to be civil in nature, okay? So when you're online and you're researching, whether because you are submitting or your N400 for naturalization or your I-485 for green card, or you've got your interview coming up, right? A couple things to keep in mind. The chance of any criminal violation is low. If you're already a non-citizen and you're in the United States, then the chance of there being a criminal indictment for mere account non-compliance, some unreported foreign income, interest income, capital gains, things of that nature not associated with the whole evading type of offshore business, chance is low, okay? Criminal violation, even if you did get indicted, let's say, that doesn't necessarily mean that you're going to be deported or removed. I mean, if it's a serious crime, then chances are you would be, but the number of those types of prosecutions that are intermingled with foreign account non-compliance, FBAR, FATCA, is relatively low, okay? And one more thing to remember, if you decide you're going to do a voluntary disclosure, not a streamlined, but voluntary disclosure, either because you are willful or you just can't certify under penalty of perjury that you're non-willful, that is absolutely not a criminal admission, okay? What it is you are unable to certify under penalty of perjury that you're non-willful. So when you're going through the process, you're seeking to avoid any potential criminal aspect while getting into civil compliance and usually paying a 50% penalty. But just because you do a voluntary disclosure, VDP, does not mean you have admitted to a crime that could lead to deportation or removal. At our firm, we specialize in offshore disclosure. We have lots of free information available on our website. You can always reach out and schedule a reduced fee initial consultation if you think it's appropriate, and it's something that we handle here. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.